Thank you very much, colleagues. We're going to move on now to the next item of business, which is Stage 3 proceedings on the Disclosure Scotland Bill. In dealing with the amendments, members should have with them the bill as amended at Stage 2, the marshalled list and the grouping of amendments. And I would remind members, as usual, that the division bell will sound and proceedings will be suspended for 5 minutes for the first division of the afternoon. The period of voting for that first division will be 30 seconds. Thereafter, there will be a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group should press their request to speak button as soon as I call the group. So we turn now to the marshalled list. Now, 1 second, Minister, sorry, yes. I call amendment, so the first group is minor and drafting amendments, and I call Amendment 1 in the name of the Minister, Marie Todd, grouped with amendments as shown in the groupings, the Minister to move Amendment 1 and speak to all amendments in the group. Marie Todd.
Thank you, Presiding Officer. The amendments in this group are minor and drafting amendments and do not make any policy changes. They are required as a consequence of amendments made at Stage 2 or to provide a consistency in drafting between provisions. Amendments 1 to 3 are drafting amendments to bring the drafting of sections 29(2) and 3 and 31(5) into line with the drafting of section 28(2), so that they refer to a review of the inclusion of the removable conviction rather than to a review of the removable conviction itself or of details of the conviction. Amendments 20 and 21 are minor consequential changes to section 73 of the bill, adding reference to a provision inserted at Stage 2. They simply mean that the persons referred to in subsection 4 of section 73 are to be notified when the ministers have decided to extend the scheme members' participation in the scheme for the discretionary membership period. Amendments 27 and 28 make technical adjustments to the wording of section 82 of the bill that gives effect to amendments to the PVG Act to bring it into line with the drafting approach of other provisions which amend the PVG Act. Amendments 30 to 34 are minor adjustments to the list of offences in Schedule 2. They are consequential on amendments made to the offence lists at Stage 2. In particular, there is no longer a paragraph 1 in Schedule 2 as a consequence of amendments made at Stage 2. References to that paragraph in subsequent paragraphs 111 to 115 in Part 3 of Schedule 2 are redundant and need to be fixed. Amendments 30 to 34 correct these now obsolete references to paragraph 1 with references to paragraph 2, which is now the first paragraph in the schedule. I move Amendment 1.
Thank you very much, Minister. And can I call Jamie Green?
Thank you, Presiding Officer. Can I just say, from the outset, I'd like to thank the Minister for coming back to the Chamber with these amendments that reflect much of the conversation that was had at Stage 1 and the Stage 1 report by the committee, and also feedback from Stage 2 as we progress through that. I will speak further on the wider bill as we go into the Stage 3 debate, but at this point I just want to say that these benches won't be commenting on groups 1, 2, 3, 5 and 6 further, and we will be supporting all government amendments that are placed before us at Stage 3. However, subject to some of the comments or speeches that may be made throughout the debate, we may interject as appropriate, specifically around groups 4 and any others that arise. But the government can enjoy our support for all the amendments today.
Thank you, Mr. Green. Does the Minister wish to make any further comments in the way of winding up?
No, thank you.
In that case, we will go straight to the question. The question is that Amendment 1 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 2, Minister, to move formally?
Formally moved.
Thank you very much. The question is that Amendment 2 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 3, Minister, to move formally?
Moved.
Thank you. The question is that Amendment 3 be agreed to. Are we all agreed? Yes. We are agreed. I'm going to turn now to Group 2, and this is on Level 2 disclosures, disapplication of provisions of Section 4 of the Rehabilitation of Offenders Act 1974. Can I call Amendment 4 in the name of the Minister, grouped with the amendments as shown in the groupings, and the Minister to move Amendment 4 and speak to all amendments in this group?
Thank you, Presiding Officer. Section 34A was inserted into the bill by way of an amendment at stage 2. It is modelled on Section 8 of the Age of Criminal Responsibility Scotland Act 2019. Section 34A lifts the protections against the normal duty to self-disclose information about spent convictions afforded by Section 4 of the Rehabilitation of Offenders Act 1974. This is so that someone who has applied for a review under Section 25 of the inclusion of a spent childhood conviction or children's hearing outcome has to answer questions and provide honest and accurate information about that conviction or outcome for the purposes of the review. Our intention is to ensure that an individual who seeks review of the inclusion of a removable conviction, whether by Scottish ministers under Section 28 or a review by the independent reviewer under Section 29, is still required to answer honestly any questions they are asked by ministers. The independent reviewer or a sheriff regarding the circumstances of their convictions, even after they are spent. Amendments 4 to 19 cater for reviews of the inclusion of removable convictions in Section 34A, bringing removable convictions into line with childhood convictions and children's hearing outcomes in this section. Amendment 5 is the main amendment that achieves this. The other amendments in the group are technical consequential amendments to the drafting and structure of Section 34A to reflect the reviews of the inclusion of removable convictions. I move Amendment 4.
Thank you very much, Minister. And no other member has indicated they wish to speak in this group, so we'll move straight to the question. The question is that Amendment 4 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendments 5 to 21, all in the name of the Minister, and invite the Minister to move the Amendments 5 to 21 en bloc?
Moved en bloc.
Thank you. Does any member object if I put the questions 5 to 21, Amendments 5 to 21 en bloc? No, that's good. So the question is that Amendments 5 to 21 are agreed to. Are we all agreed? Yes. We are agreed. Turning now to Group 3 on the PVG Act, power to require organisations to stop using individuals for regulated roles without scheme membership. Can I call Amendment 22 in the name of the Minister, grouped with Amendments 23, 24 and 29, Minister to move Amendment 22 and speak to all the amendments in this group.
Thank you, Presiding Officer. Amendments 22 to 24 are technical amendments to ensure there is a consistency of approach in relation to parliamentary procedure to which regulation-making powers are subject. At Stage 2, Section 74 of the Bill was amended to insert a new Section 45DA into the PVG Act, creating a new power in connection with the mandatory scheme. Subsection 1 provides Scottish ministers with the power to make regulations to require organisations to stop using individuals for regulated roles without scheme membership. It is an offence under subsection 3 for an organisation to fail to comply with such regulations. Section 45DA closely follows the approach in Section 35(2) of the PVG Act. Section 35(2) provides Scottish ministers with the power to make regulations in respect of stopping organisations from using barred individuals for regulated work. Although 45DA is based on Section 35(2), there is a mismatch in the parliamentary procedure under which these regulations are subject. By virtue of Section 103 of the PVG Act, any regulations made under Section 45DA1 are subject to the negative procedure. However, when read with Section 104, regulations made under Section 35(2) of the PVG Act are subject to the affirmative procedure. This issue is highlighted in the Supplementary Delegated Powers Memorandum for the attention of the Delegated Powers and Law Reform Committee. Accordingly, Amendments 22 to 24 have been brought forward to resolve this inconsistency by making regulations made under the new Section 45DA1 also subject to the affirmative procedure. I believe this is the appropriate level of scrutiny given that regulations made under this section relate to offence provisions. Amendment 29 also relates to the new Section 45DA. The new Section 47G of the PVG Act to be inserted by Section 85(3) of the Bill ensures that the Scottish courts have a clear jurisdiction over the new offences inserted into the Bill by the Bill into the PVG Act. This applies in circumstances where work is done outside Scotland that would be a regulated role if carried out in Scotland, or where an organisation based outside Scotland is sending someone to do a regulated role in Scotland. Amendment 29 adds Section 45DA into the new Section 47G to ensure that the offence of an organisation failing to comply with regulations made under Section 45DA can be prosecuted in Scotland. This amendment ensures there is consistency between all of the new offences inserted into the PVG Act by the Bill. I move Amendment 22.
Thank you very much. And yet again, I don't have any other members who wish to contribute in this section. Therefore, we'll move straight to the question. The question is that Amendment 22 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 23 in the name of the Minister, already debated, Minister, to move formally?
Moved.
Thank you. The question is that Amendment 23 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 24 in the name of the Minister, Minister, to move formally?
Moved.
That is moved. So the question is that Amendment 24 be agreed to. Are we all agreed? Yes. We are agreed. Now we're going to turn to Group 4, although I foresee a problem here. This is on the PVG Act review and report on application of scheme to elected representatives and political activity. Can I call Amendment 39 in the name of Alex Cole-Hamilton in a group on its own? Now, does any other member wish to move the amendment in the name of Alex Cole-Hamilton or to speak to it? No member does. Okay. Thank you very much, Mr. Alex Cole-Hamilton. Just in time, I think. Just in time. So I've just called Group 4, which is a group including the amendment which stands on its own in your name, which is Amendment 39. So if Mr. Hamilton would like to move and speak to that amendment.
Thank you very much, Presiding Officer, and it gives me great pleasure to apologise to the Chamber for a second time today. I had no idea we would rampage through the earlier group so quickly. I had to return an important telephone call, but my sincere apologies. Presiding Officer, members of the Education Committee...
Let's hear Mr. Cole-Hamilton now.
Presiding Officer, members of the Education Committee will be familiar with the policy intention that is behind my amendment number 39, which I move in my name. Nobody else is allowed to be alone with children or vulnerable adults without a basic check first. But there is nothing legally to stop MSPs doing it. In fact, they are explicitly excluded, and the same goes for other powerful figures within politics. That is wrong. It can't be one rule for politicians and another for everybody else. At stage 2, I was disappointed that the amendments I proposed to change didn't pass. I understand the objections of colleagues, but I hope that in my amendment today, I have found a way through that might generate more support. But despite the way the votes ultimately fell, I was encouraged by the comments of members in the committee. In amongst it all, there was an overall agreement that this was something that should be looked into. Gail Ross told me that she agreed that it is anomalous that people in positions such as ours, with the powers and responsibilities that we have, are not subject to PVG checks or something similar. Ian Gray said that the principle seems worthy, and Ross Greer said he could appreciate that what I'm trying to achieve, and also asked for a wider debate to make sure that sensible questions can be given satisfactory answers. Jamie Green told me that he shared my concerns and asked for a due process of scrutiny to do the proposal full justice. So I hope that they and other members can see what I have sought to do with Amendment 39. In the current context, this is the least burdensome approach I can think of, which achieves that objective of a proper discussion. Ministers would have until the end of June 2021 to establish a group which could involve as little as deciding the name of a chairperson. Amendment 39 wouldn't place any time limit on its reporting. Once it does report, ministers would have a year then to reflect on it and report back to this Parliament, giving enough time if it's deemed necessary for further evidence to be taken or for consultations to be run. So I move the amendment in my name, and with it a further apology for my tardiness.
Thank you very much. Can I call Daniel Johnson to be followed by Jamie Green? Daniel Johnson.
Thank you, Presiding Officer. And can I begin by just offering a little bit of personal advice that sometimes helps to be sitting throughout stage 3 proceedings if you're moving an amendment. But we'll move on from there. I had a number of concerns and criticisms of the amendments that Alex Cole-Hamilton brought forward at stage 2, namely because I think that this legislation aims to simplify the system around PVG checks and stop it from being some sort of single transferable passport enabling individuals to have unsupervised access for children. The focus on protected roles rather than protected work is very clear and is very useful, and I think his suggestions clouded those matters somewhat. Furthermore, I think it is problematic to make the assumption that by dint of being an elected politician, one should have unsupervised access to children. I think that is a very dangerous proposition. However, what I do recognise is that the position and the office that we hold may lead others to assume that perhaps we might, and indeed it might lead unscrupulous, just in a moment, scrupulous individuals to infer that they do. And so with that regard, I do think consideration is required, and therefore I think his proposals at this stage, I think, are reasonable, that the subject of whether or not MSPs should be subject to records checks and so on, I think is appropriate, and looking at whether or not there are proposals that can be brought forward. I'll give way.
I'm very grateful for Daniel Johnson giving way. I hear what he's saying about it being very unlikely that members would have unsupervised contact with children. I hear members around the chamber muttering from sedentary positions that they never have unsupervised contact with children or vulnerable adults, because that's the moral test you set yourself. That is the threshold that you decide is appropriate. I'm not suggesting that anybody in this room would take that kind of risk, but these provisions are not about people who are upstanding, law-abiding members of the public. We have to recognise that there are bad apples in politics, as there are in every walk of life, that may use their position of power to gain access to children or gain access to vulnerable adults. There is no legal or constitutional or procedural impediment in this place to stop us having unsupervised contact with children or adults. And the only safeguard we can put in place is, I believe, the same kind of checking and disclosure system that we use for all other forms of positions of authority.
Daniel Johnson.
I thank Alex Cole-Hamilton for that intervention, but I think he somewhat repeats the initial proposition that I find so deeply problematic. It's not that there is no impediment to us. It's just we simply should not be having unsupervised access to vulnerable people or children by dint of us being members of the Scottish Parliament. It is quite simple and quite straightforward, and I think to repeat that is somewhat dangerous in and of itself. Nonetheless, I think his point about bad apples is well made, and I think that our position is one such that people could infer that we do have such right. And in that narrow regard, I think his proposal for a group to be created and a report to be compiled and for those propositions to be looked at is appropriate. So with that, I will conclude and say that I'm happy to support these amendments at this time.
Jamie Green to be followed by Ian Gray.
Thank you, Presiding Officer. Just not to dwell really on the arguments that we had at stage 2, the amendment is different, to give credit to the member, and also to give credit to the member for bringing the issue back at stage 3 for the benefit of those who didn't sit through the stage 2 debate. The stage 2 debate that we had, I was a new member of the committee. Indeed, it was my first piece of legislation on the Education Committee, but it was a very comprehensive debate that we had, and we looked into that matter in great detail, and there was some sympathy, I think, to the rationale behind what the member is trying to achieve. I think he picked that up in the comments he made. From right across the chamber of circumstances why there may be benefit to the outcome, but I think there was also consensus that we felt that this legislation was not the mechanism to deliver the outcome that he seeks. The problem I have specifically with this amendment, and it's a substantial amendment, therefore it deserves scrutiny of us in the chamber today, is that what it's asking ministers to do is to set up a working group, for that working group to report back to ministers, and then ministers to report back to Parliament its plan. The problem I have with that is not that I distrust ministers, but it does put the power into the hands of politicians, and indeed, in this case, a single political party who is in government, whatever that party may be, to come forward with a recommendation on how we adapt or alter the franchise of who can be a member of this Parliament. that fundamentally puts the power into the hands of the wrong people, in my view. Yes, in a second.
Alex Cole-Hamilton.
Sorry, I just want to finish my point, that I don't think this amendment necessarily will deliver the outcome of the issue that the member is trying to raise, and I think it's a valid one. I think politicians are put in all sorts of circumstances in our constituency offices and in the course of our business. Daniel Johnson spoke at length about this in the committee stage and made some important comments and observations. But I don't see how this amendment delivers what it is the member is trying to achieve. I'm happy to give way if he wants to clarify further.
Alex Cole-Hamilton.
Thank you very much. I'm grateful to Jamie Green for giving way. I appreciate his remarks and his kind words about my second attempt on this. I think the issue I would take with his remarks to this point is that he somehow suggests that the findings of a working group would then somehow alter, as he describes it, the franchise of those people that we could elect our parliamentarians or other elected members from. That is certainly not the intention of that. In fact, I don't think it would be lawful to do that. In the same way, my original amendments were around ascertaining whether a prospective candidate or a sitting parliamentarian was on the barred list, barred and prohibited from working with children or vulnerable adults. I think that the recommendations of a group might come forward and say that the Parliament has a duty to ensure that they never have unsupervised contact, but not that they should be barred from standing for elected office. I think there's an important distinction there, and I don't think that Jamie Green recognises that in his remarks thus far.
Jamie Green.
Thank you for those comments. I mean, what is the point, therefore, of the disclosure if it is not to prohibit any individual from standing as a candidate or becoming a member? In the second part of the amendment, it defines the legislation that he would want ministers to introduce, a bill of an act of the Scottish Parliament, and that the definition of elected representative includes members of the House of Commons, member of the Scottish Parliament, and also councillors of a council. We are encroaching on other pieces of legislation and indeed legislators that we have no control over through his amendment. So for that reason, we won't be supporting these amendments at this late stage that they're introduced. But to commend the member for valiantly trying to bring the issue back to our attention. And I do hope, and I'm sure the government will reflect, and I'm sure we'll hear more about this both now and later in the debate, how the government is going to approach this issue. And we'll have the support of all parties as the government does that. Thank you.
Thank you. Ian Gray, to be followed by Claire Adamson.
Thank you very much. Mr Green is right that at stage 2 there was a pretty comprehensive examination of the ideas encompassed in the amendment that Alex Cole-Hamilton has brought forward today. And there were a number of significant problems identified by members of the committee. One was the one that Daniel Johnson referred to, the somewhat questionable or debatable idea of how it is appropriate for a parliamentarian to go about their work. But there were other problems too. There were questions about what happens and what procedures would have to be put in place if something was disclosed as part of the process of submitting to PVG. And within that, in particular, a real danger that the position of ministers might be compromised by having privileged access to information about members of the Parliament of their own party, indeed, or other parties. And to be fair, that was something that I think the Minister made very clear. They did not, a position they did not want to be placed in. But Mr Green also touched there on, I think, one of the other problems of Alex Cole-Hamilton's proposals, and that was their breadth, because these were not just proposals about MSPs. They also encompassed councillors, many of whom are members of the PVG scheme, for example, if they're on the Education Committee, but not all. But it was something that had not been discussed with or consulted on with councillors. It also covers members of Parliament, and there was some debate in the committee as to whether we would be straying then into an area beyond our constitutional powers. And Mr Cole-Hamilton made an argument that he believed we were not. I have to say I didn't find it convincing at the time. And perhaps most difficult of all, the proposal then strayed into party officials, which were poorly defined, and indeed candidates, where I do think there was some genuine questions around how the democratic right to stand for election could be also potentially compromised. And the truth is that Mr Cole-Hamilton, surely.
Councillor Cole-Hamilton.
I'm grateful to Mr Gray for giving way. I won't take up much more of Parliament's time, but I just want to ask Mr Gray, does he agree, though, that as clumsily drafted as my original amendments were, and with all the questions that he's rightly articulated, that what it comes down to is the potential for people in powerful positions, be that the chair of a selection committee or the local party chair or agent who has the power to make or break political careers, that they might use that to nefarious intent? And does he recognise that that is at this present a level of power that goes unchecked in any other way?
Ian Gray.
Don't accept that this is the legal mechanism in order to deal with something like that happening. What I do accept, and I have to accept the quotation ascribed to me that Mr Cole-Hamilton used at the end, was that I can see, with regard to MSPs, and only MSPs, an argument which says perhaps there's a principle here of why should there be a requirement we place on so many others that isn't placed on ourselves. And for that reason, and that reason alone, we are prepared to support further examination of the proposals, although we do so in the full knowledge that they may also struggle to find an appropriate resolution of those problems that the committee identified.
And Claire Adamson.
Thank you, Presiding Officer. And I can take this opportunity as convener of the Education and Skills Committee to thank my colleagues of the diligence throughout the Stage 2 proceedings for this bill. I agree with much of what has been said here, and while the intent, which we all support, and nobody in this chamber has a monopoly on giving confidence to our communities and confidence to the wider public that they are protected in the best way possible from the disclosure system, to suggest that this is a solution to the problem that Mr Cole-Hamilton has raised, I think would be misleading and could lead to confusion indeed, that there is some sort of protection there which hasn't been arrived at. So on that basis, I do hope there's another mechanism we can take this forward with, but I don't think it should be through this bill at this time. Thank you.
The Minister Marie Todd.
Thank you, Presiding Officer. I recognise Alec Cole-Hamilton's strength of feeling on this matter, and I commend his persistence on such an important issue. It is also clear that he has reflected on the debate at Stage 2 and sought to find a solution. But I still do not think that the Disclosure Bill is the appropriate mechanism for what needs to be achieved in this area. As members will be aware, Mr Cole-Hamilton lodged related amendments intended to bring MSPs within the scope of regulated roles and the mandatory PVG scheme, which were debated at Stage 2. The members of the Education and Skills Committee overwhelmingly voted against those amendments, noting that, although they were well-intentioned, this is an issue for the whole of Parliament to reflect on and to come to a consensus on matters which extend beyond the remit of this bill. I was clear at Stage 2 that the Disclosure Bill is not the vehicle to bring about the changes that Alec Cole-Hamilton seeks. That strongly remains my view. These new proposals would require Scottish ministers to commission an expert working group to consider safeguarding in relation to elected representatives and political parties within the context of the disclosure system. Ministers would then be required to lead on deciding what legislation or other options could be brought forward in response to the expert group's report. Whilst I do agree with the merits of the creation of a working group to look at the child protection issues around elected members, I do not think that placing the solution within the context of the bill and the disclosure regime is helpful. I agree with Jamie Green that it affords Parliament too little breadth of involvement, as the solution may lie in oversight of MSP conduct more generally and not simply in disclosure. And I think the Labour Party members made the same point. Alec Cole-Hamilton made the point that the disclosure system is the only solution to the problem that he presents, and I would profoundly disagree with that. The disclosure system is simply one part, albeit an important one, of the measures which exist to protect children and vulnerable adults from harm in Scotland. Situating any review within the disclosure framework could limit the range of solutions that may flow from the working group's recommendations. For instance, any legislative solution would simply take us back to the significant constitutional issues I set out in response to Alec Cole-Hamilton's Stage 2 amendments. Or, in an attempt to overcome the constitutional issues, the legislative response would essentially be toothless. Further, any legislative response within the context of disclosure would still have to overcome a number of practical issues, such as to whom a disclosure relating to an MSP would be made. In respect of the amendment, there are a few observations I would like to draw to members' attention. The acceptance of this amendment and the government's amendments on the elected representative would result in two different definitions of elected representative in disclosure legislation. Subsection 10A of Amendment 39 provides that the meaning of elected representative includes councillors of a council, which an amendment lodged in my name proposes to remove. If the amendment in my name is accepted, it means that some councillors will continue to be within the scope of the scheme. It is important to note that any proposal on elected representatives brought forward in response to the reporting of the working group under this amendment would likely encounter difficulties in terms of an actual legislative solution, given the definition of elected representatives in subsection 10A still includes members of the House of Commons. I wonder if the member, Alec Cole-Hamilton, is aware, and he referenced in his opening speech about this review coming in and reporting 1 year on from assent of this bill. And in fact, what he has done, what his amendment does, is amend the PVG Act. So the amendment would mean that that brings in a change back in 2008 because the PVG Act came in 2007. This muddle somewhat illustrates my point. Whilst the intention of this amendment is good, the execution of it is not. As I said, I do not think that this amendment is the right solution to the undoubtedly important issue that it seeks to address. However, given the importance of this safeguarding issue, I would like to offer an alternative solution wider in scope than this bill can provide for. The Scottish Government proposes to commission and fund an independent review to be chaired by ministerial appointment. This independent review, like the working group proposed by Alec Cole-Hamilton, would consider the issue of safeguarding in relation to elected representatives. The review could then make any recommendations to both the Parliament and the Government as it sees fit. However, the remit of the review could be much wider than simply looking at the disclosure system. So any recommendations could be of further reach and more effective. A wider range of voices could contribute and solutions outside disclosure could be considered. I'd like to thank Mr Cole-Hamilton for his role in progressing this important safeguarding matter. Certainly.
Cole-Hamilton.
Thank you very much, Presiding Officer. I'm very grateful to the Minister for her remarks and I'm encouraged by her offer. Can I ask, given that my original proposal suggested that this review would be instructed within a year or after a year, obviously this Minister cannot bind the hands of a future Minister or Government. So can she commit to Parliament today that if she is to undertake such a review and commission such a review, it will be done before this Parliament rises?
Minister.
Thank you, Presiding Officer. I can certainly commit to working at pace on this issue, but I think given the circumstances that we are in, with our emergency footing and our response to the COVID pandemic, I cannot commit, as you asked, but I am as keen to make progress on this issue as you are, and I am keen to make progress at pace. I'd like to thank Mr Cole-Hamilton for his role in progressing this important safeguarding matter, but I do invite him not to press his amendment and instead accept the offer of a Government-commissioned independent review. I urge members to reject the amendment if they are pressed to a vote.
Thank you very much. And I call on Alex Cole-Hamilton to make concluding remarks and to press or withdraw Amendment 39.
Thank you very much, Presiding Officer. I'm grateful to all the members who've contributed to this particular debate and offered very considered reflections. I think this comes down to the reality that people are shocked that these basic safeguards don't exist for us already. A lot of people I've spoken to and a lot of people in the media believed that this was happening already, but it isn't. They have seen the history, and inquiries expose the dangers of self-policing. They know some working in politics use their status to manipulate, target and exploit vulnerable people, and that goes for my political party as much as it does for anybody else's. Other workplaces and sectors have made huge leaps forward in creating safeguarding and a safeguarding culture. It is time for politics to start taking this as seriously. Parents should know that young people on work experience are with someone who can be trusted no matter what. Carers should know that vulnerable adults attending a surgery aren't going to be left alone with somebody who hasn't undergone any independent vetting whatsoever. I hear people again from a sedentary position telling me that doesn't happen. It might not happen with you. You may not have nefarious intent, but you can't speak to all of the political classes and all of their agendas. I was disappointed at the reluctance I encountered at stage 2, so I worked up this amendment, but I have taken heart from what the Minister has said. I'm concerned, though, that she is writing a cheque that will not be cashed in this Parliament. I hope very much. I will to Mr Gray.
Ian Gray.
Well, the member now agree with me that the Minister's offer is a good one, and that the truth is, even were Mr Cole-Hamilton's amendment to pass and be part of legislation, a future government after the election, of course, could decide to completely ignore any recommendations which the working group might bring forward. So it does seem to me that the situation is not significantly changed by what the Minister said.
Alex Cole-Hamilton.
Grateful for Mr Gray's intervention. I was coming to that. I agree. And as such, I won't be pressing the amendment tonight. And I'm grateful for the movement that the government has offered and look forward to the establishment of this review. Thank you.
Thank you. The member wishes to withdraw Amendment 39. Does anyone object? No. In that case, that's withdrawn. We move to Group 5, PVG Act, Meaning of Protected Adult, Definition of Domestic Abuse and Consequential Amendments. Can I call Amendment 25 in the name of the Minister, grouped with Amendment 26? Minister, to move Amendment 25 and speak to both amendments in this group.
Thank you, Presiding Officer. These amendments relate to the meaning of protected adult for the purpose of the PVG Act. At stage 2, amendments were made to the definition of protected adult to ensure that it is appropriately scoped and that sufficient coverage is provided by the PVG scheme. Included within the group was an amendment to make explicit on the face of the bill in relation to a regulated role with adults that involves the carrying out of activities mentioned in paragraph 16 in part 2 to schedule 3, an individual aged 18 or over who is homeless or who is experiencing or is at risk of experiencing domestic abuse is a protected adult. While that amendment was moved and agreed, I did not move the amendment providing a definition of domestic abuse. Prior to stage 2, Scottish Women's Aid expressed concerns that the definition lodged could be unduly narrow compared to people's common understanding of domestic abuse. Accordingly, I instructed my officials to further engage with Scottish Women's Aid on this matter with a view to bringing forward another amendment at stage 3. As a result of that engagement, Amendment 25 offers a revised definition of domestic abuse for the purpose of the broader definition of protected adult. I would like to take this opportunity to thank Scottish Women's Aid for their feedback and support on this matter. Subsection 2A of Amendment 25 provides that domestic abuse means behaviour, whether or not amounting to criminal conduct, that is perpetrated between partners or ex-partners, whether in the home or elsewhere, or by means of electronic or other forms of communication, and involves any form of physical, verbal, sexual, psychological, emotional or financial abuse of one of the partners or ex-partners by the other. Subsection 2B of the amendment makes clear that an individual is a person's partner if they are married to each other, civil partners of each other, living with each other as if they were married to each other, or otherwise in an intimate relationship with each other. Ex-partner is therefore to be construed accordingly. For consistency, this section mirrors the definition of partners and ex-partners in section 11.2 of the Domestic Abuse Scotland Act 2018. Including a definition of domestic abuse on the face of the bill gives certainty to those who use the PVG scheme. This is of particular importance given the offences connected with the mandatory scheme introduced by the bill. Having a definition of domestic abuse, as with the definition of homelessness, means that we are not inadvertently criminalising people who should not be within the scheme. It improves safeguarding by leaving no room for doubt about who should be a scheme member. When read with the activities mentioned in paragraph 16 of Part 2 to Schedule 3, the bill ensures that advocacy support for services for those reporting domestic abuse are covered by the PVG scheme. Amendment 26 is technical in nature. It contains consequential amendments to provisions in Section 94 of the PVG Act, which define certain terms for the purposes of the definition of protected adult to ensure that those definitions continue to work in the light of amendments made at Stage 2 to the protected adult definition. The provisions in Amendment 26 were part of the amendment lodged but not moved at Stage 2. I move Amendment 25.
Thank you very much, Minister. I call on Ian Gray.
Thank you very much, Presiding Officer. I want to acknowledge the work done by the Minister and her officials to engage with Scottish Women's Aid to try and address this point. And I know that Scottish Women's Aid are content with Amendment 25 as the Minister has moved. I know that they do have some continuing concerns which they hope will be addressed in the development of regulations and guidance. And I just would like the Minister to commit that the engagement will continue in order to reach a resolution. Thank you.
Thank you, Mr. Gray. Before I call the Minister, can I just double check? Mr. Fitzpatrick has pressed his button, but I assume that's a mistake and not... Yes, that's fine. Can I call... It's just a button. Can I call on the Minister, Marie Todd, to wind up in this section? Thank you.
Thank you, Presiding Officer. Mr Gray is correct. Scottish Women's Aid have expressed ongoing concern about the definitions in Schedule 3 and 4, and we will take action to address that. Further engagement will be undertaken on a whole range of matters that require non-statutory solutions or may require secondary legislation if necessary. Further changes to the schedules can be made under secondary legislation using the existing powers in the PVG Act.
Thank you very much. So we're going to move to the question, and the question is that Amendment 25 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 26, the Minister, to move formally?
Moved.
Thank you. The question is that Amendment 26 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendments 27 to 34 and invite the Minister to move the amendments en bloc?
Moved en bloc.
Thank you. Does any member object if I put the questions 27 to 34 en bloc? Thank you. So the question is that Amendments 27 to 34 are agreed. Are we all agreed? Yes. We are agreed. Thank you. We're going to turn now to Group 6, which is on regulated roles, definition of elected representative. I call Amendment 35 in the name of the Minister, grouped with Amendments 36, 37 and 38. Minister, to move Amendment 35 and speak to all the amendments in this group.
Thank you, Presiding Officer. As debated earlier in proceedings, an amendment was lodged at Stage 2 by Alec Cole-Hamilton on elected representatives, specifically seeking to bring MSPs and MPs into the scope of the PVG scheme. Mr Cole-Hamilton's new amendment, proposing the creation of an expert group to consider safeguarding in relation to elected representatives and political parties, was subject to debate in a separate grouping, and I will therefore limit my comments on it. The amendments in this group relate to the definition of elected representative provided for in Schedule 3 and Schedule 4 of the bill. Both schedules deal with the change from regulated work as defined in the PVG Act to regulated roles with children and protected adults respectively. Within the schedules, reference is made to an elected representative in a number of the activities which give rise to regulated roles with children and adults. These relate to the ability to directly influence decisions about the safety and welfare of a child, the ability to directly influence the operational delivery of education, medical or care services for children, and the ability to directly influence the operational delivery of medical or care services for protected adults. Where these activities are a necessary part of an individual's role and there is the opportunity to have contact with a child or protected adult, those undertaking them must participate in the scheme, except where they are an elected representative. That is, a member of the House of Commons, a member of this Parliament, a member of the European Parliament elected in the United Kingdom, or a councillor of a council. As it is currently drafted, the bill therefore excludes from the PVG scheme members of councils who, as a necessary part of their role, have the ability to directly influence decisions or the operational delivery of education, accommodation, social services or healthcare services. This is an unintended departure from the current arrangements of the PVG Act. Under the PVG Act, councillors who are members of certain committees or joint committees concerned with the provision to children or protected adults of education, accommodation, social services or healthcare services are eligible to join the PVG scheme. Indeed, many councils across Scotland make use of these provisions. In the course of Stage 2, members of the Education and Skills Committee recognised the unique role that such councillors have in influencing such services and confirmed the appropriateness of some councillors being members of the PVG scheme. In making the change from regulated work to regulated roles, we have inadvertently removed councillors on these certain committees from the scope of the PVG scheme. Amendments 36 and 38 have been brought forward to preserve the status quo and to ensure that councillors on the committees I have mentioned are required to be PVG members. I want to be clear that with these amendments, PVG scheme membership is only required for members of committees who will have the ability to directly influence decisions or the operational delivery of education, accommodation, social services or healthcare services to children and protected adults. Barred individuals will not otherwise be prevented from being elected as councillors or holding positions on committees which do not deal with the provision of services to children or protected adults. This is because of the narrow framing of the activities in paragraph 7, 9 and 25 of Schedule 3 and paragraph 17 of Schedule 4, which make reference to the exclusion of elected representatives, meaning that only councillors with the ability to directly influence certain services for children and protected adults will be within scope of the scheme. As I mentioned earlier, the Stage 2 debate and the constructive discussions on elected representatives. During that debate, it was recognised that despite both being elected representatives, that there is a clear difference between MSPs and councillors due to their roles and responsibilities. As Daniel Johnson helpfully noted, councillors may require PVG checks not by virtue of their role as elected representatives or the fact that they may hold surgeries such as we do, but because they are responsible for administering many of the social work and education institutions, organisations, systems and schemes that have direct responsibility for looking after, caring for and supervising children in local authority areas. Amendments to remove councillor from a councillor from the definition of elected representative have therefore been brought forward in recognition of that difference and the importance of preserving the status quo under the existing legislation. Amendments 35 and 37 remove references to members of the European Parliament elected in the UK from within the definition of elected representative. Following the United Kingdom's withdrawal from the European Union on 31st January this year, these references are obsolete and accordingly should be removed. I move Amendment 35.
Thank you very much, Minister. And no other member has indicated they wish to speak. The question, therefore, is that Amendment 35 be agreed to. Are we all agreed? Yes. We are agreed. Can I call amendments 36 to 38 en bloc and invite the Minister to move them?
Moved.
Thank you. Does any member object if I put these questions en bloc? No. Thank you. So the question is that amendments 36 to 38 are agreed to. Are we all agreed? Yes. We are agreed. That concludes consideration of amendments. I'm going to suspend for a few minutes shortly, but before I do that, at this stage in proceedings, members will be aware that I, under standing orders, I'm required to decide whether or not, in my view, any provision of this bill relates to a protected subject matter, that is, whether it modifies the electoral system and franchise for Scottish parliamentary elections. In the case of this bill, in my view, it does no such thing. Therefore, it does not require a supermajority at stage 3. Now, I'm conscious that some members have been here throughout the afternoon. I'm just going to take a very, very short break, suspend for 2 minutes, and we'll resume then. 2 minutes suspension.
May I call the Chamber to order, please? And the next item of business is Stage 3 debate on motion 21976 in the name of Marie Todd on the Disclosure Scotland Bill. May I say at this point that we are already late in starting, so if members would like to finish as discussed for 7 o'clock or even earlier, it is entirely in the hands of members as to how they want to put forward their contributions. And I call on Marie Todd to speak to and move the motion. Minister.
Thank you, Presiding Officer. I'm very pleased to open the Stage 3 debate on Disclosure Scotland Bill. Firstly, I'd like to thank the members and clerks of the Education and Skills Committee for their sincere and constructive scrutiny of the bill. I also want to thank stakeholders for their input throughout this process. I'm particularly grateful to those who've been able to engage with us amidst the uncertainty of the past 3 months. This is an important bill which I am glad to be able to progress at this time. It wouldn't have been possible without their ongoing engagement before and throughout the parliamentary process. Safeguarding the most vulnerable in society is at the heart of what Disclosure Scotland does, and this has been at the forefront of my mind in these very challenging times. The system that we have today is in direct response to the tragic Soham murders of August 2002, and we must never forget why this service is so important. Part 2 of the bill delivers a range of reforms to the Protecting Vulnerable Groups scheme. It strengthens this service to protect the public from those whose past conduct makes them unsuitable to carry out roles with children and protected adults. We'll introduce a mandatory PVG scheme for people who carry out such regulated roles. There's overwhelming public support for this measure to close the current gaps in the scheme, and I'm pleased to deliver this provision. We'll also provide stronger protections to those who engage in the services of another in a personal capacity, for example, those who arrange self-directed care, ensuring their employees are included in the PVG scheme. This complements the adjusted referral arrangements for Police Scotland and a new referral powers for local authorities to support Safer Scotland. This government is committed to policies which balance public protection with the right to move on from past offences. As I've said before, these are not contradictory aims. Both can be achieved. Last year, this Parliament passed the Age of Criminal Responsibility Act and the Management of Offenders Act. Part 1 of the bill further delivers on these aims by making vital reforms to state disclosure. All 3 pieces of legislation together provide a transformed disclosure system which can better account for individual circumstances. As a government, we want to offer opportunities for everyone to flourish. That includes creating a strong, sustainable workforce and making sure that no one faces unnecessary barriers to opportunity. Disclosure Scotland will continue to identify people who, given their past behaviours, are unsuitable for regulated roles and ensure that they are legally prevented from carrying one out. However, we must also allow people whose history is no longer relevant to move on. We must give particular consideration to those who were involved in the justice system during childhood, and that's especially true for care experienced people who are still disproportionately represented in the system. It's widely recognised that having a criminal record can significantly impact on future life chances and outcomes. Since becoming Minister for Children and Young People, I have heard powerful testimony from young people who have had to overcome significant trauma and who should not be haunted by mistakes made in their childhood. We have to do more, not only to prevent such experiences from happening in the first place, but to limit the damage that is done to individuals, families and communities in the long term. These children must not be left behind. Throughout the bill's progress, we've heard evidence of care-experienced young people self-excluding from roles which ask for disclosure. Whether they exclude themselves due to childhood mistakes or uncertainty around how to navigate disclosure, this bill will transform their access and allow their voices to be heard. With the bill, there will be no disclosure period for the vast majority of childhood convictions, as they'll be immediately spent under the Rehabilitation of Offenders Act in Scotland. Public protection will be served by provisions which draw a line around only the most serious criminal behaviour in childhood. This most serious behaviour will remain eligible for state disclosure, and there will remain a duty on the individual to self-disclose it when asked by an employer while unspent. I'm absolutely committed to ensuring the reforms in the bill are clearly communicated to young people and those who support them. I recognise that even with these reforms, the disclosure system can be intimidating and difficult to understand. I look forward to working with our stakeholders to ensure that everyone is able to access their rights moving forward. The Education and Skills Committee recommended at stage 1 that guiding principles for decision making are on the face of the bill. Working together, we've ensured that these are included and applied to decisions under this bill, the Protection of Vulnerable Groups Act and the Age of Criminal Responsibility Act. That will provide helpful legal clarification on how decisions are made. Once again, I'm very proud to be moving the motion on the bill at stage 3. At the heart of every justice reform this government has brought forward is our absolute belief that people are capable of change. Over these last 3 months, tens of thousands have volunteered to support their communities in these incredibly challenging times. Some of these people may even have committed offences in the past, but today they are positively contributing to our national effort. This bill maintains and strengthens the safeguarding offered by state disclosure. However, it also recognises that people should be able to move on from their past. I move the bill in my name.
Thank you very much, Minister. And I call Jamie Green.
Thank you, Deputy Presiding Officer. Can I thank members for their patience this evening? I think we're getting to a stage where the legislation that we are passing has been amended appropriately. I thank members for their forbearance. I was new to the committee. I'd like to thank Liz Smith for dumping the bill on my desk on my first day in the education brief. It's clear that at stage 1 and the events leading up to the production of the stage 1 report, this was a very complex piece of legislation that required very detailed analysis of the effects and consequences of what the bill would achieve. I think is demonstrated by the large number of technical amendments that are tidying up at stage 3. I think show how difficult it was even for those who were drafting in the government to get the bill into a good place. I'm not going to comment too much on many of the previous discussions we had around what the bill achieves, but I think it's important that we thank those who gave evidence to the committee for doing so. And also reflecting on the importance of a bill like this. You know, the whole point of the disclosure process going back since it was first established is really to protect children. And I think this Parliament has made great strides in various guises of legislation to do so. This adds to that collection of bills that I think we all will be proud to have worked on in the session of this Parliament. I'd also like to thank the Minister for steering it through Parliament and also reflecting on some of the feedback that members gave. I think as we look forward at why this is important, as the Minister said, we're on the cusp of a volunteer revolution because of the coronavirus. So many people are coming forward to get actively involved in helping in the third sector and the voluntary sector. And it's important we strike that balance between how do we protect children and the safety of children against welcoming people into the system. I had an amendment that I tried to introduce at stage 2 around people under the age of 16 who are keen to engage in the voluntary sector and whether or not they would require vetting. And we had a good debate around that. It's important that we do invite and encourage everyone and anyone who wants to get involved to do so. But the process behind that needs to be robust, transparent and accessible. The committee, for example, raised at stage 1 some concerns around moving to a digital-only system and whether that would work for all groups and organisations. And I believe the government has reflected on that. And in the current situation where we need to encourage people into environments where they will interact with children and vulnerable people. For example, there is talk about getting retired teachers into the education system quickly and efficiently. How do we do that? Using the disclosure system to ensure that large numbers of people who come forward are able to access services quickly. As we encourage people into social care, where we know there already is a requirement for more people. As we encourage people into the third sector, into nurseries and other environments where these checks are important. The only thing I'd like to pick up on really in my brief comments is what's changed, and that's comments made by the Minister in the Stage 3 amendments around the suggestions from Mr Cole-Hamilton around how we further protect those that we have to, involving anyone who's involved in political life. The Minister briefly mentioned the setup of an independent review, I believe was the language used. All I would ask is, I think that's very welcome, but I would ask that the Minister either writes to Parliament or indeed to the Education and Skills Committee with more detail around that. I don't think now is the time and place to go into that, but I would invite the Minister to do so, so that all members can read more about what the remit of that will be, the timescales and the expectations around that. I'm going to close my comments there in the interest of time. Thank members for their input into this bill, and it's been a pleasure to work on it in my first piece of education-related legislation in the committee, and I know that the hard work of the committee will continue as we look to improve outcomes for all children across Scotland. Thank you.
Thank you, Mr Green. Colleen Gray, please.
Thank you very much, Presiding Officer, and can I draw the Chamber's attention to my register of interests, where it says that I'm the chair of the Burning Community Foundation. At stage one in the debate that we had on the disclosure bill, I spoke a little bit about this being the latest stage in a kind of roadmap of protection legislation, which goes all the way back to the start of the Scottish Parliament and the first act that we passed, Adults with Incapacity, and then passes through things like protection of vulnerable adults and so on. So this evening brings us to the end of this bit of the road, and I think although it's been a bit bumpy sometimes at stage two, we've reached a pretty good place, and I think that the Minister and her officials have tried very carefully to respond to the concerns of the committee and the witnesses, and that's good to see. One of the points that I made about these kind of bills was just how wide-ranging they are. And it is a fact that early on in the committee evidence, it was revealed to us that there are 1.5 million members of the PVG scheme. So it's certainly legislation which affects very, very many of our citizens. And of course, that was one of the reasons why there was a move in this legislation to having membership renewable every 5 years. And while the committee did look at some practical issues around that, repeat fees, for example, people having to remember that they have to renew their membership of the scheme. I think the important thing is that it does allow Disclosure Scotland to work more efficiently and effectively in monitoring members of the scheme by not having to do that for a significant number of members who are not actually using their membership of PVG. So that's quite important and quite effective. Of course, the other thing about that early legislation was that they were all good examples of how having our own parliament allowed us to catch our legislation up with other legislation and with the modern world and other changes much more readily. And so I don't think we should be surprised that having set the disclosure scheme in place, we now come to a point where it's necessary to clarify and simplify and modernise it. It had to take account of other legislation we've passed, like the Age of Criminal Responsibility, the change there, the Management of Offenders Act as well. And again, I think a great deal of work at stage two went into trying to make sure that that happened, and we've got there now. And of course, it won't be the end of that, because the government has just recently recommitted itself to the incorporation of UNCRC, for example, and that may well be a legislative change which will come back on some of the measures here around children and childhood offences, which will mean that we have to come up with another iteration of this scheme. There is some more immediate work, though, which is quite important, and not only the setting up of the group which was promised to Alex Cole-Hamilton earlier on. In the course of discussions, there were concerns. Jamie Green mentioned this about the fact that anyone under 16 could not be a member of the scheme, and I think a commitment was given because there were concerns that might make it difficult for those under 16 to volunteer at all. And I think the government committed to monitor that and ensure that that was not, in fact, the case. And similarly, the Children's Commissioner has expressed concerns around the impact of the legislation on care-experienced young people. And again, that's something where I think the government committed to to monitor it, and I hope that they will be able to do that, perhaps as part of the care review implementation. So some immediate work, but the biggest immediate work, of course, is for Disclosure Scotland, because when the original scheme was introduced, colleagues will remember that there was a period where it took quite a long time for disclosure checks to come through, and that caused great difficulty for a lot of voluntary organisations and indeed workplaces. So Disclosure Scotland made us promises they could make this legislation work. Let's hope they're right. I think we've got it in a place where they should be able to make it work, and we will certainly be supporting the bill this evening.
Thank you, Mr Gray. I now call Ross Greer, who is joining us remotely.
Thank you, Presiding Officer. I should start by reminding the Chamber that I'm a current member of the PVG scheme through the Church of Scotland. Rehabilitation and reintegration into society for people who've committed an offence in the past is a key part of creating a more just and safe society, but it's one that must be balanced with safeguarding vulnerable people against those who may still pose a risk. Getting that balance wrong has serious consequences. A system that's too punitive would create cycles of reoffending as those with past convictions face obstacles to mainstream employment and instead pushed to the periphery of society. That's still very much part of the reality here in Scotland, despite our efforts, and we have no shortage of examples of more punitive systems where reoffending rates are even worse. Being too lenient, though, would leave people, particularly vulnerable people, at risk. We would fail in our duty to safeguard their well-being. The disclosure system must balance these issues and set out robust procedures for when past convictions should be disclosed. Over time, the system's become pretty complicated. Its legal framework stems in large part from the 1974 Rehabilitation of Offenders Act. But since then, a significant volume of further legislation by the UK and then by the Scottish Parliament, instruments, court cases, have created new rules and schemes. As a PVG scheme member, I certainly welcome the bill's aim of simplifying and strengthening the system. This isn't an easy task, as the Education Committee saw at stages 1 and 2. While broadly supportive of the aims of the bill, a number of issues were raised about aspects of the current system and proposed changes, and those required addressing. I was not the only one to raise concerns about the impact of barring under-16s from PVG membership, as Ian Gray and Jamie Green have mentioned, while still permitting those same young people to engage in regulated work and simultaneously making it an offence for anyone aged 16 or over to engage in regulated work without PVG membership. There are currently several hundred under-16s engaged in these type of roles, mostly on a voluntary basis. And my primary concern was that organisations, often small voluntary organisations, would take this as a message that under-16s could no longer engage in this kind of voluntary work, or even that if they were technically allowed to, the legally safest option for the organisations was to avoid this. Another concern worth noting, again, is that the small number of under-16s who do present a risk and are barred by ministers from working with vulnerable groups could slip through the net without the PVG scheme applying to them. I appreciate the government's position that having under-16s in a continuously monitored scheme is disproportionate, and that in any case they should not be engaging in regulated work without an adult who is a PVG scheme member themselves present. And I understand that other disclosure products are available. This was a finely balanced argument for me, but I am content with the government's commitment to monitor the impact of these changes on participation from young people in volunteering and to communicate clearly the other available disclosure products, and that the introduction of the offence for engaging in regulated work without PVG membership does not apply to these young people. And I acknowledge the literal handful of under-16s who are barred and do pose a risk should be monitored by other statutory services, preventing a situation where they would engage with vulnerable groups. But as I said at stage 1, relying primarily on overstretched social work departments is far from perfect, particularly in situations where such an individual may move between local authorities. That's often where communication between services can break down. The other substantive concern I raised at stage 1 was the two-part test for level 2 disclosures, to be established at a later date following consultation with stakeholders. While I appreciate the importance of such consultation, this could have left parts of the system dealing directly with balancing privacy and safeguarding without any parliamentary scrutiny. So I'm pleased that the government introduced amendments at stage 2 to address that issue by providing further provisions within the bill on how that test should be applied. I also welcome the changes that have been introduced to address the other issues that have been raised by both MSPs and organisations such as Women's Aid during stage 1 and 2. In closing, Presiding Officer, the Scottish Greens welcome these steps to simplify and strengthen the disclosure system. We thank the Bill team, the committee clerks and those who contributed evidence for working towards a set of proposals which we are happy to support. Thank you.
Thank you, Mr Gray. I now call Beatrice Wishart, who is also joining us remotely.
Thank you, Presiding Officer. This bill concludes my first full experience of scrutinising legislation in the Scottish Parliament since being elected last summer. So I firstly want to put on record my thanks to the committee clerks and the legislation team who have helped guide me through the process. And I'd also like to thank my committee colleagues for their support. Ahead of any legislative reform, I can see that there's a power of work that goes on behind the scenes, and that's even more impressive in the current context. And so I pay tribute to all those who are somehow keeping the Parliament ticking in these extraordinary times. I said at stage 1 that this bill has the potential to make genuine positive changes to the disclosure process. And I'd like to focus on a couple of the specific ways that I think that will happen when it passes today. Making it possible to apply for and to receive disclosures digitally will be an important and significant step towards the future. It has taken a pandemic to prove that parts of Scotland's administration are just pointlessly reliant on paper, and that's not the way the world works anymore. Offline alternatives are obviously still needed, and I do still have some concerns about IT capacity in light of the 1.2 million people that may need to reapply for PVG as the renewal system gets underway. But if the disclosure system can maintain accessibility and make this move a success, I'm hopeful that it will create a precedent that other systems can follow. The bill also makes sensible changes to the PVG scheme. Renewable 5-year membership, which will be mandatory for those in regulated roles, puts the scheme back in line with the reality. Disclosure Scotland say that 20% of the people currently included in the scheme that don't need to be there. And so that's hundreds of thousands of people being monitored for no reason. Ending lifetime membership should address that pointless intrusion and the needless burden on Disclosure Scotland. I'm also really glad this bill will end the automatic disclosure of childhood offences committed between the ages of 12 and 17. Mistakes made in your early years should not prejudice your adult life chances. Scotland still has some way to go as we strive towards incorporation of the UNCRC, but I welcome each move made in that direction. So as I say, I think this bill will make good changes to the disclosure system, but I can't finish my contribution without mentioning the amendments submitted by my colleague Alex Cole-Hamilton, which did seem to me were completely in line with the policy aims of the bill. It's clear that politicians fit within the definition of power and influence. And it's also clear that situations can and do arise as part of the role of an elected representative where it could be used improperly. It's not enough to say that it shouldn't. The point is, I think, that it could. So although the amendment today has not been pressed, I hope that because of my colleagues' work to raise the issue and the welcome announcement by the Minister of an independent review to look at this safeguarding issue, there will be a change in the future. And so on that hopeful note, I'm happy to support this bill today.
Thank you, Ms Wishart. And we now move on to the open debate. It's speeches of 4 minutes, but can I say to all contributors that we are already quite well over time, so brevity would be appreciated, I think, by everyone. And I call on Claire Adamson to be followed by Jeremy Balfour.
Thank you, Presiding Officer. And can I thank the colleagues who have spoken already this evening and covered many of the points that I would have wanted to raise in regard to the Disclosure Scotland Bill. I am very thankful to our clerks and to all those who took part in the deliberations at stage 1 of this report. I remember an evening quite late on in the Parliament in one of the rooms in Queensberry House, and people had travelled far and wide to come and take part in that focus group. Something that would almost be unheard of now, since this all happened just before we went into lockdown, and no doubt it would have happened by Zoom nowadays. But And it also delayed a little bit of the proceedings going forward. So it seems a long, long time ago since we were last in the chamber discussing the bill. But I think it's in a good place, as has been said by many people. I think the work of the stakeholders and the work of the bill team and the government has been evident by how easily it went through at stage 3 this afternoon, and the consensus across the chamber with regards to what's there. If I can just highlight one thing that came to light, and it's about the progressive nature of this bill and the issue with regards to young people and children having convictions that happened to them when they were younger being disclosed, and that impact. And it was a really emotional piece of evidence to take from the people that took part in the focus groups. And it was Robert Dorian asked us to recognise that adolescence is a unique phase of life by ending the automatic disclosure of convictions accrued while aged between 12 and 17 years, and introducing an assessment by Disclosure Scotland acting on behalf of the Minister as to whether convictions ought to be disclosed. And one of the people from Who Cares Scotland informed us that although those who have been in care make up an estimated 0.5% of our population, they make up 33% of Scotland's youth offender population and 31% of Scottish adult prison populations. And that should all make us stop and think about what we are doing systemically in the care system that would lead to this situation. And as Ross Greer so rightly said, you know, it's so important that these young people have an opportunity to take part. So we are in the COVID era now, and if anything, this bill is more important than it was beforehand, because we want to harness that energy that has been shown by people and a willingness to volunteer. And I think we're in a good place to make sure that that can be carried out effectively going forward with the bill as it stands today. So thank you once again to everyone who contributed to the bill process.
Now, we seem to have lost Jeremy Balfour, and I'm hoping it's just temporary. So I'll call Daniel Johnson meanwhile.
Thank you, Presiding Officer. You caught me off guard there. I've got my iPad. Well, thank you very much. Given that it's 25, not even 23 minutes before we all want to be out of here, I'll try and be very brief indeed. I would just remark upon the fact that the reasons why we have this legislation are important ones, which set out by the Minister and also Ian Gray. But I think also what Ross Greer said about essentially this legislation being one of balance, a balance between rights and responsibilities, obligations and expectations. In addition to the reasons already set out by members why this legislation is important, I just add one more, which is I think the giving people the ability to see the information that's being disclosed about them in job interviews, I think is a very welcome one. I think foreseeability is another very important issue. The main line of questioning I pursued through stage 2 and indeed during evidence for stage 1 was around the two-part test. I think one of the most important concerns that was raised was about whether or not information which wouldn't be disclosed if it was a matter of a criminal conviction could be disclosed if it was part of ORI, other relevant information. And I think putting the principles on the face of the bill helps greatly. I think the one additional point I would make is clearly the guidance that will be put around those principles will be hugely important in terms of ensuring that information is safeguarded, that information which wouldn't be disclosed if it was a matter of criminal conviction isn't disclosed simply because it's other relevant information. The one other point I would like to raise is something that the General Teaching Council for Scotland has been in touch with me about. They play a very important role in terms of regulating who is a member of the teaching profession. However, they have been in touch with me to state their concern that information that they need in order to understand and assess whether or not people are right and proper people to be part of the teaching profession simply isn't coming to them, either from Disclosure Scotland or from Police Scotland, both of those bodies citing GDPR. Indeed, it's somewhat ironic in that in order to gain accreditation in the first place, that PVG information is required. However, if there is new information and a police investigation, and even if that is made aware to Disclosure Scotland, the details of that aren't passed to the General Teaching Council, nor do the police alert them. I think that's an issue that does require some urgent attention. It is an issue which in Ireland, the Information Commissioner there has said that that information should be. And indeed, my understanding of GDPR legislation is that when it comes to child protection, that information sharing is permissible. So I'd urge the government to look at that. And with that, I will sit down. Thank you very much.
And now call Rona Mackay.
Thank you, Presiding Officer. I'm happy to speak in this Stage 3 debate on a bill which is incredibly important to the Scottish Government's ability to protect the most vulnerable in society. In a nutshell, when passed today, it will modernise and improve proportionality in the disclosure system, balancing public protection with the right to move on from past offences. It's a progressive and very necessary bill. We've seen significant amendments and improvements made to the bill in its journey from Stage 1, and I thoroughly recommend its passing today. As we've heard, it's a detailed bill with many parts, and I commend the Minister and her officials for getting into such a good place. The Law Society and COSLA support the development of a simplified regime for disclosure in Scotland, balancing an individual's right to privacy with protection of the public interest, and acknowledges that the current disclosures regime is complex and difficult to navigate. As Daniel Johnson said, the two-part test was greatly debated in committee, and the Scottish Government and Disclosure Scotland have outlined the approach around guidance, both statutory and non-statutory, and the Law Society are keen to contribute to this work. Presiding Officer, for me, one of the most vital parts of the bill relates to childhood offending. Children should not serve a lifetime sentence of discrimination and unemployability for offences caused in childhood, many as a result of adverse childhood experiences. The bill will end automatic disclosure of convictions accrued between 12 and 17 years. And for adults, a fundamental aim of the disclosure regime is to balance public protection with the right to move on from past offences. A theme of policy discussions is how care-experienced young people can be particularly susceptible to becoming involved with criminal justice agencies, as the Minister and the convener have articulated. One care-experienced witness, Robert Dorian, said care-experienced individuals often self-exclude, which cannot be quantified. Our members have told us that childhood convictions have prevented them from moving on from their past. That needs to change, and the bill is an opportunity for that change. The bill will simplify and modernise the disclosure system, with applications being made online. By applying and receiving disclosures digitally, the process is expected to be faster. However, the committee also welcomes reassurances from Disclosure Scotland that non-digital means of seeking disclosures will remain. Presiding Officer, I'm delighted that Amendment 25 defines the meaning of domestic abuse, and I thank Women's Aid for their involvement in this. Alec Cole-Hamilton's amendments to the Disclosure Bill, which were withdrawn, but I'm pleased and really pleased that to hear of the working group proposal outlined by the Minister. So, in the interest of brevity, in conclusion, Presiding Officer, the bill is a hugely progressive one, and it will strike the balance between protection and allowing people to move on with their lives. And I'm happy to support it at Stage 3.
Well, I'm afraid we haven't been able to get Mr Balfour back. Oh, he's just arrived. There he is, in the nick of time. So we haven't made up all that time I was hoping for, but never mind. Jeremy Balfour.
Apologies, Deputy Presiding Officer, and I will keep my comments brief. Technology let me down there. I, unlike the other members who have spoken, I think so far in this debate, come to this bill new and have been able to read with interest the Stage 1 debate and the amendments that have been put forward. I come with a real interest. I am a current member of the scheme. I think I hold 3 different certificates for volunteering that I do. I think one of the really important parts of this bill is pointed out by the Law Society of Scotland, because the current regime is complex and it is difficult to navigate. And I welcome the changes that this bill will bring about and will make the scheme easier. And clearly there is a very difficult sometimes balance in getting right. We want in every circumstance to protect children and vulnerable individuals. But at this other time, we want to encourage as many people as possible to come into volunteering. as others have already said in this debate, I think there's a greater awareness of what volunteers can do since this present crisis, and we want to make sure that that happens and continues to happen. So I think this bill has got the balance right, and I think it will encourage people to volunteer, but making sure that they are the appropriate individuals. I also do welcome the comments by the Minister and by others today in regard to giving people a second chance. I think that is a really important principle. We all make decisions which we live to regret with, and particularly perhaps individuals make decisions they regret in their youth. And for that to always hold them back from being able to volunteer, to be able to give back to their communities, I think has been rectified in a great deal by this bill. So I know, Deputy Presiding Officer, you want us to move on. I know many have had a long day. Let me tell you, it's no more comfortable sitting in a chair in your study than it is sitting in the chamber. So I will stop my remarks there and welcome the bill and look forward to it becoming an act.
Thank you very much, Mr Balfour. I'm glad you managed to get into the debate finally. We'll move to the closing speeches, and we're not too bad for time now. Just up to 4 minutes, please, Mr Gray.
Well, thank you very much, Presiding Officer. And yes, I hear the up to 4 minutes. We find ourselves in the twilight of a wet Wednesday in a sparsely populated chamber in the middle of a deadly pandemic. And indeed in the shadow of a powerful debate on racism which ranged across the globe and across the centuries and dealt with matters of good and evil and life and death for far too many people. So I think at this stage less is more, really is the truth. But I do want to say this though. We should be proud of our Parliament and pleased with ourselves for doing this today, because completing this bill is, I think, a symbol of something very important. The purpose of the disclosure regime is to make two things possible in safety. Firstly, the professional caring and nurturing of the vulnerable, teaching, caring, helping children, supporting people with disabilities. And secondly, all the volunteer-supported activity in our communities, which adds so much richness to our life and opens doors, many of which many of our young people would never even get to stand in front of. Youth clubs, scouts, BBs, every kind of sports club you can think of, and more besides. These are things which create joy in our life, and disclosure is about ensuring that they can happen in the confidence of safety from any who would pervert them for their predatory purpose. And they are the very things that COVID has closed down. Caring has become a frontline battle, while the fun and companionship of sport and clubs has closed down altogether. That Hibernian Community Foundation that I chair usually runs children's community football across the whole of the south of Scotland, holiday camps, and I can tell you that we do not expect that to start for a very long time. But start again it will. And by taking the time today to complete this bill, even as so much of what it affects is in abeyance, signals our hope, our confidence and our determination that those activities which enrich our normal life with joy and fun and caring will be back. Children will play again, they will learn again, people will meet together again to socialise and support each other, and they will do so in safety. And that's not a bad night's work.
Oh, I don't think your card's in properly. In fact, your card's not in at all. Like we've got all the time in the world here. Jamie Halcrow-Johnson, up to 5 minutes, please.
Thank you very much, Presiding Officer. My apologies for that, and thank you to all the fellow speakers for giving me so much time to be able to expand on the points I wanted to make on today. Increasingly, organisations from businesses to the public sector are faced with difficult questions about safeguarding vulnerable people and how they accommodate those people who have previously been convicted of crimes. This has always been a delicate balance and reaches to the heart of our justice system. There's been a great deal said on the sometimes competing interests of retribution, rehabilitation and reparation. In more practical terms, we know all too well the problems faced by institutions where vulnerable people, especially children, have not been adequately safeguarded. Too many lives have been destroyed and too many people still carry the scars, physical and mental, of abuse that could have been prevented. It's right that the needs of victims and those who are at risk come uppermost in our considerations, but it must be the case that we recognise the broader needs of society and those who have criminal convictions. This is what the Minister dubbed the right of people to move on from their past behaviour. Criminal behaviour carries, in many cases quite properly, a stigma, but once a person is released into the community, we cannot expect them to find constructive rehabilitation if they cannot contribute through employment, but also, if appropriate, through other means such as volunteering. Today's bill is a welcome one, which streamlines a complex system and helps users to navigate it more effectively. Some of the work at Stage 2 has also improved the legislation. And the need for effective rehabilitation among people who committed offences as children is even more pressing. The broad direction of travel seems to have been widely welcomed. It does place weighty powers in the hands of the Scottish Government to decide what is reasonable in any particular case, and that must clearly be used sensibly, with a consideration of what is not only serious, but presents a serious future risk. Undoubtedly, a number of these provisions will have to be monitored once they are implemented. This is no criticism of the Government's bill, but simply an acknowledgement of the difficulties inherent in this area of law. Presiding Officer, this bill makes sensible changes to a vital system that provides protection for some of the most vulnerable in our society. There are a great many provisions in this bill, and it would be impossible to touch on them all, despite their importance. However, what is necessary is that the principles and purpose of these systems this bill creates and modifies are foremost in our minds. What is being proposed makes a number of substantial improvements, and those of us on these benches will be supporting it today.
As the way things go, Minister, if you could speak for a wee bit longer than that to which you were allotted. Marie Todd, if you take us to just before decision time, that would be useful. Thank you.
Thank you, Presiding Officer. I'll hastily replace all the pages back into my speech. I want to start by giving thanks to all the members for their contributions this afternoon, and again to thank the Education and Skills Committee for their detailed scrutiny. This is a technical bill, and it has been difficult for all of us to understand the drafting of it and the detail of it. But the meaning of it and the purpose of it is very clear, and it's a very powerful, serves a very powerful purpose in our society. I want to thank the Bill team. They've been mentioned several times around the Chamber. They have indeed done a sterling job of working with both stakeholders and with parliamentarians to ensure that we could understand the detail of this bill. And if you'll indulge me for one moment, the Bill team leader has a significant birthday today and is hopefully watching at home and with a wee glass in hand. So well done, Kevin Lee, and happy significant birthday. The passage of this bill will not be the end of the journey. It is the vehicle to provide greater protection, opportunity and flexibility to people and to businesses in Scotland. As I've previously set out, the Scottish Government will consult widely on disclosure fees before these are laid for the Parliament's consideration. I understand all the more acutely in this time how important this will be to individuals and to different sectors. We have a long-standing commitment to fee waiver on the PVG scheme for volunteers with qualifying voluntary organisations, and that will continue under any revised arrangements. As a temporary measure, we have also removed the fee on applications for key workers and volunteers who are contributing to Scotland's response to COVID-19. Engagement doesn't end with the bill, and if it is passed, as I hope it will be this afternoon, we will continue to learn from stakeholders in the many communities with an interest in this bill, working in collaboration with them, finding out more about what works best and welcoming scrutiny and challenge. Daniel Johnson mentioned the General Teaching Council, and I'll use them as an example. It is absolutely vital that we work with stakeholders to get things right for them. It is vital that we're able to share certain information with regulators for the purpose of safeguarding, and that's why my officials have engaged with GTCS and other regulatory bodies on this matter. After the GTCS raised its concerns with Disclosure Scotland, they reviewed the practice and made changes so that when Disclosure Scotland notifies the GTCS that a teacher is being considered for listing, it will always state the source of the information. And that will allow the GTCS to use its powers to ask for the information from the organisation that owns it. And recent improvements have focused on better communication between the GTCS and Disclosure Scotland about such cases. Certainly.
Look, I'm very grateful for the Minister
Daniel
giving way
Johnson.
and for addressing the point. I was just wondering if she might reflect on the point regarding the police, who the GCCS are also mentioned as being part of the issues that they face in terms of obtaining this information. Thank you.
Marie Todd.
Yep, certainly happy to work to continue to improve that information sharing relationship, because it is important. And I have to make clear that if new information is added to a scheme member's scheme record that results in the scheme member being placed under consideration for listing, then regulatory bodies and employers would be notified. Disclosure Scotland have developed a new IT system, and they now control it themselves rather than being dependent on an external supplier. And recently, this has enabled them to quickly implement solutions in response to COVID-19. That would have been significantly more challenging under the previous system, and their ability to quickly change the system allows Disclosure Scotland to make positive and sustainable improvements that will enhance their ability to deliver the bill and to protect vulnerable groups. And the bill's implementation will build upon the existing new system at Disclosure Scotland, and the estimated costs set out in the financial memorandum for this bill remain valid. I think at this moment in time it is important to highlight the significant work which has been undertaken at Disclosure Scotland in responding to the COVID-19 crisis. The requirements of home working and the national imperative to get health and care workers checked without delay required Disclosure Scotland to rapidly deliver change. Their response has been phenomenal. Stakeholder feedback has been incredibly positive about the changes Disclosure Scotland has made, and I give my thanks to everyone at Disclosure Scotland who has made this possible during these unprecedented times. While, of course, Disclosure Scotland needs to be in a position to implement the provisions, stakeholders must be ready too. Digital delivery is just one aspect of implementing these provisions. Some elements of the bill will alter how organisations approach their recruitment practices, and we need to ensure that they are confident in their new rights and responsibilities before the provisions of the bill come into force. True to our approach from the very outset of reviewing Scotland's disclosure system, we will work closely with the stakeholders to map out the steps from the current situation to the post-bill services. The transition from regulated work to regulated roles must be handled very carefully and at a pace that our stakeholders are comfortable with. Stakeholders have been very clear with us about wanting to do this in a collaborative and iterative way. These changes won't happen overnight. It's not only Disclosure Scotland that needs to be ready, stakeholders must be ready too. We're committed to developing better training and guidance, which will be co-designed with stakeholders to ensure it's more targeted and suits the needs of our users, including children and young people, and those who support people with convictions. This bill shows that we are absolutely focused on protecting the most vulnerable in our society, but that we also recognise that people can and do change, offering a more responsive and individualised approach to state disclosure. Taken together with other recent acts, the Management of Offenders Scotland Act and the Age of Criminal Responsibility Scotland Act, we will transform the situation for Scotland's children and young people, so many of whom have been marginalised and stigmatised because of state disclosure. At stage 1 of the Age of Criminal Responsibility Act, we heard moving testimony from Lindsay Hanbridge. Lindsay described receiving a criminal charge during the traumatic experience of being taken into care while she was aged 13. This was very affecting evidence that both members and I reflected on throughout the journey of that bill, right up to the final debate at stage 3. We know that, unfortunately, Lindsay's story is not unique, and that care-experienced young people are more likely to have interactions with the criminal justice system. It is in recognition of this that the provisions of this bill, building on the Age of Criminal Responsibility Act, have been developed, and I believe they will have a transformational impact on the life chances of someone like Lindsay. The bill provides that some of the barriers to a better future can be removed. I am delighted to commend this bill to Parliament.
Thank you very much. And that concludes our debate on the Disclosure Scotland Bill. The next item of business, point of order, Sarah Boyack.
Thank you, Presiding Officer. First Minister's questions this afternoon, Richard Leonard raised concerns regarding the provision of personal protective equipment for frontline NHS and social care staff. During his exchange with the First Minister, he spoke about concerns which staff have raised directly with him, and I quote, "Staff tell me that their PPE is suboptimal and that they are still being instructed to use PPE that is out of date, including critical equipment such as FFP3 respiratory masks. Will the First Minister give NHS and care staff a guarantee that PPE guidance and supplies will be enhanced, that out-of-date PPE will be withdrawn immediately, and that regular and routine testing will be rolled out without further delay?" While Richard Leonard was raising these concerns on behalf of our hard-working frontline staff, the Cabinet Secretary for Health and Sport, Jean Freeman, shouted lies, lies about those concerns which were being raised. Presiding Officer, not only do I believe it's unfortunate that the Cabinet Secretary for Health and Sport used unparliamentary language in the Chamber, I am concerned that behaviour and response to legitimate questioning will act as a barrier to the many hard-working NHS and social staff coming forward in the future to raise concerns. Presiding Officer, what action can you take to ensure that those on the front line can have their voices heard in this chamber through elected members without accusation from a Cabinet Secretary that the information they have provided is lies? Thank you, Presiding Officer.
Can I thank Ms Boyack for giving me advance notice of the point of order. I should say that I was in the chair throughout this procedure. I didn't hear any discourteous remarks shouted across. One second. I did not hear any remarks shouted across the chamber. However, I would take this opportunity just to remind all members from all parties to treat each other with respect, not to make remarks from a sedentary position, and certainly not to use unparliamentary language. The concerns that Ms Boyack has raised are now on the record, and I hope she'll be satisfied with that. Now, can we move on to the next item of business, which is consideration of Business Motion 21999 in the name of Graham Day on behalf of the Bureau setting out a business programme. Could I call on Liz Smith to move the motion?
Move, Presiding Officer.
Thank you very much. No member has indicated they wish to speak in the motion. Therefore, the question is that motion 21999 be agreed. Are we all agreed? Yes. Thank you. The next item is consideration of 4 parliamentary Bureau motions. Could I invite Liz Smith on behalf of the Bureau to move motions 22000 and 22001 on designation of lead committees, and 22002 and 22003 on approval of SSIs?
All move, Presiding Officer.
Thank you very much. So we turn to decision time. The first question is that Amendment 22004.1 in the name of Pauline McNeill, which seeks to amend motion 22004 in the name of Christina McKelvey on showing solidarity with anti-racism, be agreed. Are we all agreed? Yes. We are agreed. The next question is that amendment 22004.2 in the name of Patrick Harvey, which seeks to amend the motion in the name of Christina McKelvey, be agreed. Are we all agreed? Yes. We're not agreed. Move to division, and members may cast their votes now.
just before decision time, there was like flashing lights on several of the consoles and they don't appear to be working. So how can we record
Okay, I said, Mr. Doris, your microphone's not on, so I'll just, if you just pause a second. For the record, Mr. Doris has just raised concerns that we're not confident that the terminals were all working. The vote as recorded shows a majority of 50 to 11. I'm just going to have a short consultation and I'll decide in a minute whether to carry on. Hang on 1 second. Short suspension. I'm just going to have a short suspension, Mr. Doris, and I'll return. Short suspension. Thank you, members. Parliament is resumed again. Mr. Doris, do you wish to raise another point of order? Do you want me just to explain what's happening now? Point of order, Mr. Doris.
Apologies, my microphone's not working. I've tried 3 consoles now and none of them have been working. So if I can't stop this on the regular point of order, presiding officer.
Okay, I wonder if you could project. There we are. Mr. Doris.
Each of them informed me that I was already logged into 3 different consoles. I cannot explain that, presiding officer. Neither can you. I don't expect you to explain that, but I do expect my vote in support of this to be registered here this evening.
Indeed. Just for members' information, the consoles are showing the members that are present. There were only 4 votes that weren't registered there. However, it is an important point that members who have made the effort to come today and wish to signal their support for these either acts of parliament or motions get the chance to do so. So I'm going to run this vote again and we'll see what happens after the vote. So the question is, and this is a vote on the amendment in the name of Patrick Harvey, amendment number 22004.2, which seeks to amend the motion in the name of Christina. Okay, point of order from from Claire Allison.
The consoles haven't cleared, so it's showing a vote before it's called.
In that case, we'll just pause while we clear the consoles and then I'll take the vote again. A short pause while we clear the consoles. Now, we believe that when we run the vote again, the consoles will clear and members will be able to cast their votes. However, if they don't, we will examine proceedings. So, on that note, members may now cast their votes, and this is on Amendment 22004.2 in the name of Patrick Harvey, amending the motion in the name of Christina McKelvey. Members may vote now. So, 63, and there's 2 that can't. The result of the vote on amendment number 22004.2 in the name of Patrick Harvey is yes 52. There were no votes against. There were 11 abstentions. The amendment is therefore agreed. Now, the names of all those who voted will be available in the business team office, the chamber desk, several minutes after decision time. So if members are concerned that their vote wasn't registered, if they could contact me by email later this evening. However, it's noted that Mr Doris has cast his vote against the amendment for the record. The next question is that motion 22004 in the name of Christina McKelvey as amended on showing solidarity with anti-racism be agreed. Are we all agreed? Yes. We are agreed. We are agreed and that motion is agreed. So the fourth question is that motion 21976 in the name of Marie Todd on the Disclosure Scotland Bill at stage 3 be agreed. And this is legislation, so members should cast their votes now. The result of the vote on motion 21976 in the name of Marie Todd is yes 63. There were no votes against. There were no abstentions. The motion is agreed and the Disclosure Scotland Bill is passed. Now, I propose asking a single question on the 4 Parliamentary Bureau motions. Does any member object? The question is that motions 22000 to 22003 inclusive in the name of Graham Day on behalf of the Bureau be agreed. Are we all agreed? Yes. We are agreed. And that concludes decision time. Thank you, members. I close this meeting.